Hi, this is Jumi,
And this is Catherine,
and welcome to the Rabideau Law.
Business Law Show.
On the show, Catherine and Jumi discuss everyday business law questions and issues that come their way with the aim to simplify and enlighten. This is a 4-part series show. Information shared on the show does not constitute legal advice.
Hi, Jamie. How are you this morning?
Hi, Catherine. How are you?
I'm good.
I'm good too.
Good. I was thinking we've been talking about the other day we were talking about incorporations, and we also talked another time about share purchases. And I think one thing we do also that relates to those matters and that we have clients asking us about are shareholder agreements.
All right.
So after you incorporate a company or buy a company, should you have a shareholders agreement in place?
Right.
I think about in school they taught us the 5 W's. I don't know if you know why, where, when, what. I always forget the other one. But so I was thinking, what is a shareholder agreement? Why
Right.
do I need one? And when do I need one?
Right.
Talk about that.
Yeah. And I mean, I like where you started from. Started from incorporation. That's always the beginning, right? Where we
Right.
incorporate, and upon incorporation, we issue shares. So some corporation you realize, and this is fine, where the incorporator, the person, the business owner, maybe, is the director, the officer. By officer, we mean the president, secretary, treasurer, and is a sole shareholder. In that situation, I don't really worry about shareholders agreement. But the moment, and I think I'm already answering questions that we get about when should I prepare a shareholders agreement. The moment you add another person to the shareholders of the corporation, maybe you had 100% shareholding before, then you diluted it, and maybe you have 90% and someone else has 10%. Even if you have 99% and someone has 1%, that is the moment you prepare a shareholders agreement.
Okay.
A shareholders agreement is a contract. You can call it a contract between the shareholders of the corporation, and it defines all their rights, the restrictions, what they can do and what they can't do.
Okay.
It defines it. So we put in a lot of things into the shareholders agreement, right? We put in what happens in the case of disputes. Really, that's what a shareholders agreement is about. Really, it talks about down the line. If so, right now we're all fine. We're new shareholders, and we can't even think of a situation where there will be disagreements among us.
Right. It's the honeymoon phase.
Pardon me?
The honeymoon phase.
Exactly.
Right?
It's very difficult to see that we'll ever disagree over anything. Well, I see the shareholders agreement, and I've heard a lot of people call this too, like a prenup, right?
Right.
Where it's something like it, right? We're still in the honeymoon phase and everything is fine. But somewhere down the line, what if things go south? And then how are we going to solve the disagreement? So that's what a shareholders agreement is. If the shareholders have disputes down the line, how do we solve it? Do we go to arbitration? Do we go to mediation? Or do we go to courts? Or so a shareholder wants to exit. I think that's the biggest, for me, that's the biggest thing in in a shareholders agreement. You don't want to be stuck. Okay, a good example is maybe we have 4 shareholders in a situation. They're all business partners and they're doing fine. Then one shareholder dies. Then when the shareholder dies, the wife wants to take over his shares, or the partner wants to take over the shares. The other 3 shareholders, maybe they didn't even like the wife or the partner. So how can you be in business with someone you don't like?
Yeah.
Right? That's where shareholders agreement comes in.
Okay.
The shareholders agreement would have settled that from the beginning. In the event of the death of a shareholder, what happens to its shares? Can the spouse take on the share, or do the other shareholders have the right of first refusal, right, where the shares are sold to them?
Right.
So the
Yeah.
shareholders agreement covers exit strategies, or maybe a majority shareholder gets a fantastic offer from a third party, and then wants to sell the share to this third party. What do the minority shareholders do?
Yeah.
So the shareholders agreement will have those exit strategies and protection for majority shareholders, minority shareholders. We just settle everything like a prenup. What
Right.
happens when? So I think that's the beauty of a shareholders agreement. The moment you have more than a shareholder in your corporation, you
You
should
should
prepare.
do it.
Yeah.
Okay. So if a corporation starts off with 2 or more shareholders, they should do it right away.
Right. Absolutely. And even sometimes when just one shareholder, but the shareholder is already anticipating that there will be investors, right? And then prepares a shareholders agreement in anticipation.
Right.
Yeah.
Now, what happens if one shareholder leaves and a new shareholder purchases either their shares or at a future date buys shares in the company? Do they have to create a new shareholder agreement, or can they use the old one? How does that work?
I think it depends on so there are different types of shareholders agreement. There are different clauses that you can put in. So if from the get-go you have it in the shareholders agreement that the shareholders agreement binds even new shareholders, but you have to let them know that there's a shareholders. So if someone comes and buys a percentage share in the corporation, it's important to let them know there's a shareholders agreement in place and it's binding upon you. Right. So you can have that clause. But also in practice, we realize that there's situations where a shareholder comes, a new shareholder comes on board, but it's not in agreement with that shareholder's agreement. And you don't want to lose this new shareholder. Then an amendment, they can call for an amendment to amend the shareholders agreement or create a new one entirely. But definitely you can have a clause in it where it binds new shareholders coming on board, and they need to be the duty of a corporation to let them know that there's a shareholders agreement in place.
Okay, that makes sense.
Right. I
So,
think.
Sorry, go ahead, Jumi.
Yeah, I think another question that we do get is can a shareholders agreement have, how does it protect me when a shareholder leaves and starts a business?
Right.
Exactly like the business that we have in the corporation.
Now there's a competition,
competition, exactly. And that's where clauses like either you put it in the agreement or you have it separately. I have things in the agreement. Non-competition clauses and non-solicitation that you don't take our clients along with you, right? Non-competition. Not that you can't create your own business like ours, or you define the radius, right? Maybe within a particular kilometers away from us, you can move away and all that. So that's the beauty. You can have as much clauses as you want, as long as it's fair,
right,
and legal. Then you can put it in the shareholders agreement.
Okay. What about if a shareholder has to leave? Is there any sort of financially they've encountered problems, things like that? Is there any kind of exit strategy that can be put into the shareholder agreement?
Right. I think, yeah, if a shareholder wants to leave, right?
Yeah.
And I think the main thing will be in a situation like that, will likely be that he wants to sell the shares.
Yeah.
And we always put in right of first refusal, so that before you go to sell the shares to outsiders, third parties, you offer it to the shareholders in the corporation first. Right? So that's usually the situation. They most likely will buy off your shares, and then at least you have some money to go and cater for but right of first refusal comes in.
Okay.
I remember the last we were discussing the last time I came up to you, and we were discussing about that one was about a share purchase, right?
Mhm.
Not shareholders agreement, share purchase.
Fair purchase,
And we're
yeah.
talking about you're a friend. My friend
Yeah.
wants to buy a corporation, and we talked about do I need to prepare a formal or should I just make it oral? This
Yeah.
also is similar, right? If I say the shareholders coming on board are all my friends.
Mhm.
Do I need something? We can always solve this. No, you need to put things in writing. You need
Yeah.
to put things in writing, let them sign, define things. Do
Mhm.
you know actually all these contracts, they actually strengthen relationships. Like we've had contracts called co-ownership agreements where people they
Yeah.
just want to, they might be family members or friends, but they want to define we own this property together and we want to define
Mhm.
our rights and a percentage ownership and all that. You have
Yeah.
cohabitation. We're living together.
Yeah.
So, but we're living together and we're family, that's fine. But
Mhm.
we still want to define our rights and how are we going to share our expenses?
Yeah.
If you want to sell this property, what is the percentage share? How much are you bringing in? You know,
Yeah.
you put all those things in an agreement because it's very easy to forget.
Yeah. And it saves headaches down the road. If,
Exactly.
things, if the relationship changes, you still have this agreement. You came to this agreement when you were on good terms, and you have to abide by the contract that you entered
Right.
into. It makes things a lot easier than trying to figure these things out if the relationship changes,
Yeah.
and arguments happen and things like that. If you already have these things in writing, it makes it so much easier
Right.
at that point in
Absolutely.
time. Yeah.
Yeah. And it might save both the relationship and the business
Yeah.
and save both. Uh,
Yeah, exactly.
I really like this clause that I really like it putting into agreements generally, mediation, dispute resolution, because you
Yeah.
never know,
You
right?
never know.
Dispute resolution, how are we going to solve this in case? And if you hear people say, no, we're so good. Like, yeah, I know you're good. How are you going to solve? So we just put the standard dispute resolution clauses
Yeah.
there so that when you eventually need it, you just go to it.
Yeah. And you may never need it, but at least it's there.
Yeah, it's
Just
better
in
not to
case.
need it and have it there
Yeah.
than, right? Very correct.
Because when
And
you get married, you never think, oh, 10 years from now I'm going to separate.
exactly,
But sometimes these things happen,
it happens,
and
exactly. And then your separation agreement comes into place. So
Yeah.
your marriage contract comes
Yeah.
into place. Very correct. Very correct.
Yeah. It's just in case. It's not saying that anything's going to happen, but
Right.
you should be protected just in case.
Just in case,
Yeah.
yes.
Yeah.
And I just don't really believe in anything oral.
No.
Make some documentation. I
Yeah.
mean, sign it and just keep it somewhere.
Yeah.
Later, if it's like we said, if it comes in handy, good. If you don't need it, fine.
Yeah.
Yeah.
Exactly.
Well, I think that's basically what a shareholders agreement is about. You prepare it's binding among the shareholders. You prepare it upon having more than one shareholder in the corporation. You can prepare it as a sole shareholder, but I mean, it becomes necessary the moment you bring on another shareholder.
Right.
The agreement, I mean, into the corporation, and then it states all your rights, restrictions, what you can do, how you would do it, dispute resolution, exit strategies. Like it's like being in a marriage and you want to get out,
Yeah.
but there's no means, you're stuck.
Yeah.
So this allows that, right?
Yeah.
You have your exit strategies.
Yeah.
If this happens, this is how I'm going to get out.
Yeah.
If someone dies, this is how we're going to do it. If someone becomes disabled, because that's also a disability clause is a big deal. If someone becomes disabled, if it is just like not fully, they
Yeah.
can still walk. This is how we do it. If it is full disability and they can't go on, this is how we handle it, you know. So you put all those things already in place. So when it eventually happens, you have a way out.
Right, exactly. Exactly.
Yeah.
Great. That was awesome, Jumi. That was very informative. Thank you.
Thank you. Thank you, Catherine.
All right.
All right, see you.
I'll see you later.
All right, later.
Okay.
Bye.
Bye.